Welcome to Conversations with My Real Friends. I'm Jennifer. On this episode, I'm going to be talking about the Burnett Sitzer lawsuit, how it's affecting real estate, and what it means for you as a real estate professional. Listen on to learn more. Then let's talk about Missouri and the civil lawsuit. So this was a lawsuit filed in Missouri. It was a class action lawsuit. The plaintiffs were sellers of homes in Missouri who signed a listing agreement and paid a realtor commissions. The position was that the way commissions are set up, cooperating commission and the seller paying the buyer's agent, resulted in them overpaying commissions. So again, they signed contracts and agreed to numbers, but their position is that they overpaid. And it goes to, again, the antitrust laws, because if you have set up a system that is harming consumers, that's when you can invalidate a contract. So that's the case law that we're dealing with. It was a jury trial. Not one person on the jury was a homeowner, right? It was a very young jury, right? Millennials, right? And they found for the plaintiffs. They found that the realtors were violating the law. And they not only did they find the case, then they decided damages, and they awarded $1.8 billion in damages. That was the damages award. National Association of Realtors was only one defendant in this case. Anywhere Real Estate, which owns Coldwell Banker, Better Homes and Gardens, Remax, Keller Williams, and Home Services were all defendants in this case. Some of them settled before the case went to trial. They got out easy, right? Some of them, everybody has settled, right? Or at least has agreed to settle. None of it's final yet. Everybody has now agreed to settle. But the people who settled before got way better deals than the people who settled afterwards. If the settlement holds, what's going to happen from a realtor standpoint is there's four things that NAR has agreed to. The first is $418 million in damages, right? It's a lot better than $1.8 billion, but that's still a lot of money. $418 million to be paid over 4 years. The second thing they did is they expanded the class, right? So a class action lawsuit, the plaintiffs are called a class. That's the terminology. In this case was only in Missouri, so it only impacted Missouri homeowners. Well, settling for $418 with just some people in Missouri, when you got 49 other states to deal with, is not a viable solution. The result is that they've expanded the class to every homeowner throughout the country who worked with a realtor for like the last 5 years, right? Which means, you know how you get those little postcards in the mail, right? Because you bought a phone and they think they overcharge you and you're going to get like a $2 credit on your bill in 10 years, right? That's what's going to happen. The homeowners are going to get like $10, right? Everyone who sold a house in the last 5 years is going to get a check for $10. I'm not making this up, right? That's what's going to happen, right? But because the idea of expanding the class is that you knock out all the statutes of limitations, right? So you knock out anybody because the day after the Burnett Sitzer case was filed, lawsuits were filed in every state. We had 2 major ones in California, right? Again, just defending those would have put them out of business from a legal fees standpoint. And assuming it went the way it did in Missouri, 1 or 2 other cases losing, it's all game over. So this plan mitigates, doesn't solve, it mitigates the risk and damages. The third piece is that they have agreed to prohibit listing the cooperating commission on the MLS. This is what the DOJ is upset about, which means I think it's going to be even worse. I do believe that cooperating commission will no longer be on the MLS. I do think that's going away. But right now, the expectation is that if I'm a listing agent and my seller is willing to cooperate, that I can advertise that. I can put it on my social media. I can put it on my YouTube page. I can put it on the flyers that my seller is cooperating. I think that's all going to go away. I'll just tell you, that's what we think the DOJ is aiming for, is that each side's going to pay their own fees and that there's not going to be cooperation. I don't know if that will happen, but that's what the DOJ wants. Okay. The fourth piece is that the buyer's agents, now, if they're going to do a listing or show a house, will need to have a contract with that buyer before they can do that. Okay. So those are the four things they agreed to. The second two are about the path forward. If they didn't change their practices, this was going to keep happening. The issue that they're having to fight could not be resolved without a change in practice. So this was their compromise position. Whether it's the best compromise position or not, I can't tell you. And whether it's what we will ultimately get, I can't tell you. But that's what's on the table today. So as of now, sellers can still offer cooperating commission. It's still on the MLS today, right? They did not put out the new listing agreement. So the listing agreement still has all the cooperating commission on it, right? It can now currently be on the MLS, but once the rules go into effect, it will not be. But you can advertise it. What's going to happen, though, is now you can negotiate commissions and you can negotiate price, right? So under the old rules, if part of why people were selecting properties based on commissions was you couldn't ask for more than what the seller was offering, right? So under the listing agreement, if the seller said, I'm going to pay 2%, the buyer's agent or the buyer couldn't ask for 2.5 or 3. That was a violation of the MLS rules. That's gone now. So I have a seller who's giving their agent 3%. Well, I'm a buyer. I'm going to say, I'm offering you $1 million and I want you to pay 2% to my agent. Or I'm offering you $900,000, but I'll pay my own agent, right? So we're going to start seeing purchase price offers and commission cooperation offers, and we're going to be negotiating on 2 fronts instead of 1. Yeah. So you're going to be looking at net sheets, right? You're going to have to look at the price, but you're going to have to look at the net sheet to see who's actually offering the most money based upon the commissions, okay? And you know what that means? They're going to ask you for the discount, right? The agents are where, like, I know I'm an escrow person, right? Like, we're always where they're asking for a discount, right? And I laugh because we're the lowest price. Escrow's the smallest number on the whole damn list. And everybody wants us to cut our fees, right? It's because, and we're going to talk about this later today, it's because escrow doesn't do a good enough job of articulating their value. People don't know what escrow does. So if you don't know what they do, what am I paying you for? We need to do a better job in escrow of doing that. And you guys as agents are now going to be having to do the same thing with buyers. We never had to articulate our value to buyers before. Now we're going to have to, okay? So my crystal ball, and this is coming one way or the other, is that commissions are going to be decoupled. So right now, the listing agreement calls for the commissions. And so how does the buyer's agent get paid today? Do you guys know how this works? They get paid through the MLS. The MLS is the contract, right? Because the buyer doesn't agree to pay them and the seller doesn't agree to pay them. The listing agent doesn't agree. There's no contract, right? If I'm a buyer's agent, what contract do I have to earn my commissions? It doesn't exist.
Until you write the offer and it's accepted, and then
correct, and
that
it's
agent has
and their duty is because of the MLS, because the amount they offered to the MLS. The MLS is the contract that is the bridge between the listing agent and the selling agent. They broke the bridge, right? So the only way the buyer's agent gets paid now is either by the buyer or the seller. They're not going to be paid by the listing agent anymore. So there's a CAR form called CPC, this commission cooperation form. It's gone. I'll just tell you. Like, they haven't said that yet, but I'm telling you right now, that form is going to go away. The forms that are going to be used are the listing agreement, the BRBC, the buyer rep agreement, and the seller to pay buyer broker agreement, the SPBB form, right? So the seller is going to agree to pay the commissions or not, and the buyer is going to agree to pay the commissions or not. There will not be money going between brokerages anymore. That's going away, right? So this is the bootleg copy of the new buyer rep agreement. All right, you cannot find it on CAR's website anymore, but all of the brokers just have it, right? Like we've all seen it, but I don't know if it will ultimately come out like this, right? Because we don't know what's going to happen. But this is what they were proposing. So like the new listing agreement, the grid has, so as someone who, like most of us don't really like change. Change is something that bugs us, right? A year and a half ago, we got the new RPA and the new grid, and it scared all of us to death, right? It was a huge change in the forms. I love the grid. Actually makes, especially from an escrow standpoint, everything's in one clean, easy place to find it. But everybody was scared to death when we got the new forms. The new forms are way better. So they've seen how well the new forms are working. So they redesigned all the forms to have a grid, like all the purchase agreements. But again, these are now, but that's what we're talking about, is how we're talking about commissions. And look, I mean, way different than what we see today on these forms. This is the new RPA language. This did go into effect. So there's two things that changed relative to commissions. So section 18A of the RPA. Now, if the seller agrees to pay the obligation of buyer to compensate buyer's broker, seller shall be entitled to a copy of the written portion of the compensation agreement between buyer and buyer's broker, identifying the compensation. So in order to ask the seller to pay your commission, if you're the buyer's agent, you have to have a buyer agreement. That's required. And then you have to give a copy to the listing agent so they can see, and the seller, so they can see what you agreed to. Because you're not allowed to ask for more than what they've agreed to pay you. Okay? The other thing they changed, escrow holder, so this is 19D for my escrow people. Escrow holder shall provide to buyer and seller, either jointly or separately, a closing statement or other written documentation showing the amount of compensation to be paid to, respectively, buyer's broker and seller's broker. So I have created a new mutual commission instruction. Everybody gets to sign it. The buyer, the seller, the listing agent, and the selling agent. Everybody sees all the numbers. That's a huge change for us from a disclosure, California privacy rules. Now everybody's going to see all the numbers. Okay? So these changes did go into effect.
And you don't anticipate any revisions?
I think things are going to continue to evolve, but I do not think they're going to pull back on this all being public. The whole
premise is
correct. The whole issue was not being transparent, right? So all the things that are going towards transparency, I don't think are going away. Okay. Now, as an escrow person, do not give each other's closing statements to each other. Don't do it. CAR's not escrow people. CAR writes stuff in their contracts we don't like. A mutual commission instruction is fine. Do not give each other their closing statements. Yes.
So, is there now, should we be sending the mutual?
On any contract, any deal you get on this new contract,
Okay.
once you start getting deals on the new RPA,
It's
right out.
Now? Okay.
Yes. So you need a mutual commission instruction. So send me an email. I will send it out. So, and I know RBJ and SMS and all them are working on it too.
Okay.
Okay. Oh, I want to do this slide. Go back. So this is the grid from the RPA, right? This is section G3. This is not new. This section was put in when they created the grid. It says, and there's a checkbox, seller agrees to pay the obligation of buyer to compensate buyer's broker under a separate agreement. Now, most agents don't get buyer broker agreements, but if they did, and now they will, right? And then they ask for the seller to pay, that's how the compensation is going to flow, right? So if you're doing it without the MLS, we're going to be using the SPBB form. So hope I'm going the wrong way. So this is the bootlegged SPBB form, right? So that's going to be that agreement for the seller to pay the buyer's agent's obligation, the buyer's obligation to their agent to pay commission. The buyer is not going to get double paid. The buyer can't get 2.5 from the buyer's agent can't get 2.5 from the buyer and 2.5 from the seller, right? They get paid once, but it'll be based upon whatever the number they've negotiated with the buyer relative to their commissions. They can ask for the seller to pay all or part of what they've agreed to. So if I'm a buyer and I've found an agent I love and I'm going to pay him 3%, but the seller's only offering 2%, I can ask the seller for the 2%, and then I would pay the 1% still, right? So the buyer would pay the 1%, the seller would pay the 2% to the buyer's agent, and then the seller would pay whatever they've agreed to pay to the listing agent. From an escrow standpoint, this is accounting chaos, right? And if so my recommendation from a settlement standpoint, if the buyer has agreed to pay a commission, like through a buyer-broker agreement, I want you to show that cost on the buyer side, on the closing statement. If the seller has then agreed to pay all or part of it, it should be an offset, okay? So the number, because that flows with the contracts. The buyer agreed to pay, and then the seller agreed to pay, and it's an offset, okay? So all the numbers will be on there. It won't all just be on the seller's like we're used to seeing.
And depending on who's paying the commission, that price of that house has to reflect that.
The appraisers are all freaking out, right?
Yeah, exactly.
The appraisers are like, how do I appraise this? Because
Exactly.
if the commissions are one thing on one property and on a different property,
That's messed up.
correct, it's
It's so messed up.
it's chaos,
It is chaos.
right? That's where we're at. We're in the chaos mode, right? We're in the stages of grief, right? And we're in that anger, frustration phase. We haven't hit acceptance yet, and right? We're working our way through that process, okay? But again, from an escrow standpoint, I want you to get a copy of the listing agreement. I want you to get a copy of the buyer-broker agreement, and I want you to get a copy of the seller to pay buyer-broker agreement. So you have all the numbers so that you make sure you're putting everything on the right side, because if you get it wrong and you don't pay the right person's commissions, you get to pay it, right? So we don't want to get this wrong, and we don't want to trust what no offense, agents, we don't want to trust what the agents tell us they've agreed to, because they don't always even realize, right? So, so there is another new form. So this one came out in May. Traditionally, CAR releases forms twice a year, December and June, but because of all the questions about commissions, they actually released this new buyer compensation advisory in May. So this is out there. I like this form. Again, this probably will not stick when all is said and done, but it's helping, because like my mom, who's here, right? She's selling a property. When she decided to list that property, we talked about the commissions and how to pay them. And she's like, well, I know there's this thing going on. How should I do this, right? She's a consumer. If it's in the zeitgeist, right? If consumers know about this, they're asking questions, they need someone to help them with some answers, right? So this form is a good benchmark of what's going on so that the consumers can understand to then make an informed decision about how they want to proceed on their own personal transaction, okay? So this is the August 17th proposed MLS changes. Again, I don't think this will stick. They said it will, and you know, I would bet money this date won't stick. All right, but all this goes to the whole cooperation thing. All the new 9 rules all go into that.